According to the law, I am a reformed criminal. I'm going to discuss my role as a first-time offending criminal within the justice system, where my rights applied and where they were violated, and the involvement of the law enforcement. The following statements are the reasons why you should take Introduction to Criminal Justice 1100. When I was 19, I was driving home about 1 o'clock in the morning, and I got pulled over because my plates were expired for about 3 days. After pulling me over, the arresting officer came to my window and asked me for my insurance and for my license. The insurance I did not have, and my license was suspended. After giving the officer my information, I had noticed that a second officer had started to pull up, and that's when the first officer informed me that I was under arrest.
Law enforcement officers can initiate an arrest only under the following conditions. Number 1, arrest warrant issued by the court. Number 2, when they observe a violation of the law. Number 3, under exigent circumstances, that is, circumstances in which, unless immediate action is taken by the police, the evidence may be destroyed or the suspect may escape. Number 4, when they have probable cause to believe that someone has committed a crime.
After informing me of my arrest, the officer put me in cuffs, pat me down, and then asked to search my vehicle, to which I said yes. Then he proceeds to ask me if there's anything illegal in the car that he needs to know about. I said yes. There in the front passenger seat, there is a backpack with a black box in it, containing marijuana. Well, how much is there? There's 7 grams, 2 joints, 3 pipes, 2 grinders, and about ½ gram of hash oil. After they found the illegal substances, they bagged it up as evidence, searched the rest of the car, found nothing else, and then put me in the back of the arresting officer's car. Well, that's when the second officer comes over, reads me my Miranda rights, asks me if I understood, and to which I said yes.
In the famous case of Miranda v. Arizona, 1966, the U.S. Supreme Court issued an opinion in which it summarized all of the rights of a citizen during police arrest and interrogation. The officer first questions the suspect without advising the suspect of his or her rights. If a confession is obtained, the suspect is advised of his or her rights, and a second interrogation is performed. The assumption is that it is easier to obtain a confession without advising the suspect of his or her Miranda rights. The first confession is discarded, and the second confession, the one in which the suspect was advised of his or her rights, is used in court. Miranda rights are based on the rights against self-incrimination guaranteed in the Fifth Amendment. Thus, defendants have the right to remain silent during interrogations in their trials. Defendants cannot be compelled to provide testimony that may incriminate them. Furthermore, the law provides that the prosecution cannot say or imply to the jury that a defendant's silence or refusal to testify at his or her trial implies guilt.
When they took me to the county jail, they processed me right away because I was the only one there. Normally they would put you in a holding cell, but again, I was the only one. While they're processing me, they took my fingerprint, they copied my ID, and they ticketed me with 2 felonies and 3 misdemeanors. The 2 felonies were possession of drugs, and the other one was possession of drug paraphernalia, as in the pipes. The 3 misdemeanors were driving with suspended license, driving with no insurance, and driving with expired plates. After ticketing me, they assigned me a case number. I could either pay bail and go to the court date, or I could wait in jail and wait for them to take me to court then. Luckily, I had the money on me, so I paid the bail and was able to go home that night. But I was still given the papers for a court date, as well as all of my tickets. In order for me to sign the bail release, I would have to pay 10%, I would have to post 10% of what the actual bail was. So I paid $150, and the actual bail was $1,500.
The Supreme Court has declared that excessive bail must be based on standards relevant to guaranteeing that the defendant will not take advantage of his or her freedom and flee prior to the trial. Thus, no standard limits of excessive bail apply to all cases. The court has the power to consider each case individually based on the totality of the circumstances.
I also started receiving tons of letters in the mail from different types of lawyers and law firms and things like that, people who generally looked at my case. So I ended up finding a lawyer from a letter that caught my eye. His letter gave me a lot of detail about my case from both sides of it, not just the misdemeanors of my license, but also the felony charges of the drug possession. I ended up contacting him after hearing my story. He said that if what I said was true, then he would be able to get the felony charges dropped off of my case and be able to reduce my tickets and jury. The reason why the felony charges would be dropped is because my lawyer said that my Miranda rights were violated. I self-incriminated by telling them where the marijuana was, and the main arresting officer did not read me my rights. And the second officer, who did read me my rights, was not on the report.
Confessions given freely prior to an opportunity for police to advise a suspect of his or her rights are admissible, and confessions given to third parties are admissible.
So the first court date shows up, and I paid my lawyer $300 for the first visit, and he wanted $1,000 overall to help support me in my case. The first court date got pushed back because we did not have the audio evidence ready. The county jail police officers did not give us the evidence, so we needed to wait until they gave it to us for us to pursue the case further. So we finally got all the evidence that we need, and we have a court date. And the state's attorney initially wants $8,000, $1,500 for each count of the drug paraphernalia, $1,500 for the possession of drugs, and the $500 for each count of the misdemeanor. He also wanted 100 hours of community service, and he wanted me to go through drug therapy and have my license be revoked for 2 years. After we presented the evidence, a plea bargain was struck because it was found that, yes, my Miranda rights were violated, and the state's attorney still wanted me to go to drug therapy, but the felony charges would be dropped. Now, the reason why he still wanted me to go to drug therapy was because if I had been caught with marijuana possession, they want to ensure that I'm not going to relapse. So it's just a system trying to make sure I go back. I also was going to have my license revoked for 1 year. I would need to go back and retake driver's education and have SR22 insurance. So basically it's a permanent way of me having insurance for a few years. And to top it all off, I'd still have to pay $1,500, $500 for each count of misdemeanors.
Sentences must be fair and cannot discriminate on factors such as race, sex, or religion. The pre-sentence investigation report is important in providing a fair sentence. A pre-sentence investigation gathers information about the convicted offender to help the judge determine the appropriate sentence. This report includes the defendant's employment history, family relationships, and reputation in the community.
I broke the law. Because of my lack of understanding of the Miranda rights, I incriminated myself. Because I incriminated myself, I was able to get the drug charges dropped. Had my lawyer not further informed me of my rights, I could be a convicted felon right now. It is very important to be knowledgeable of your rights because you never know when you could be in a bad situation with the law. These are some reasons why you should take Introduction to Criminal Justice 1100.